One of the challenges facing advanced societies with universal healthcare systems is how to afford the rising cost of pharmaceuticals. In the mid to late 2000s, the National Health Service in the United Kingdom started a program where they offered financial incentives to doctors to get them to prescribe less expensive but still clinically appropriate medications. Naturally, this wasn't great news for the industry. The industry noticed, however, that the European Union had a directive binding on the UK which said where medicinal products are being promoted to persons qualified to prescribe or supply them, no gifts, pecuniary advantages, or benefits in kind may be supplied, offered, or promised to such persons unless they are inexpensive and relevant to the practice of medicine or pharmacy. The UK government responded that that rule was intended to prevent private enterprises from essentially bribing doctors into prescribing their medications. And they claimed that the rule did not apply to government agencies who were acting in order to further their policy of providing healthcare for their whole population. In a preliminary opinion in the European Court of Justice, Advocate General Jaskinen boiled the dispute down to a policy versus a principle. He referred in this context to the jurisprudence work of Professor Ronald Dworkin, and in particular to Dworkin's identification of the concept of principles which underlie the law, but which do not create freestanding rights or rules. In this case, the pharmaceutical industry was relying on a principle. The principle was that government should not interfere with the clinical decision-making of medical practitioners, who should be free to prescribe whatever they consider is in the best interests of the patient. The government, however, was relying on a policy which said essentially that the principle being cited by the industry had to be affordable, as there was no point medical practitioners prescribing medications that the individual could not afford to buy and that the health system could not afford to supply. The court said it is permissible for public authorities to determine, on the basis of evaluations of the therapeutic qualities of medicinal products, by reference to their cost for the public budget, whether certain medicinal products are, from the point of view of public finances, preferable to other medicinal products. So while the principle was still valid, in this case the policy of the government validly departed from it.